All right, good evening, everyone. Thank you for joining us. I'm going to go ahead and kick us off because I think we're just about at 6:30 p.m. We tend to have about a third of the audience sneaking in between 6:30 and 6:45. So when they come in, just glare at them. Look at your watch. But we have a lot to get in, so I'm going to go ahead and kick off. Thank you for joining us for our International Child Protection Lecture this year. We do host this every year. Our aim is really to bring professional communities together, to talk, to listen, to share their experiences. We've had a very illustrious history of speakers, everyone from Isabel Trowler to Baroness Butler-Sloss, Lady Black, and of course last year we had Sir James Munby. I will introduce our absolutely fantastic panel in a few minutes, but before I do so, I wanted to say a huge thank you to Herbert Smith Freehills, who is hosting us this evening. Can we just give them a quick round of applause? And I should add, this is being recorded, which is why I did that round of applause for them. We will share the link to this recording if you want it. It probably will be available on our website from next week. We are not operating Chatham House rules tonight, so please do feel free to continue the conversation on social media. If you want to include CFAB, we're at CFAB UK. There's our first one, guys. Glare. And of course, you can include Herbert Smith at HSF Legal. So I hope everyone had a chance to have a tea or some water, because we are going to have a lot to talk about today. I've got an agenda for you, which really begins with me as the warm-up act. I'm going to tell you a little bit about CFAB and why we do these every year. But your main event is going to be our panelists, who are each going to give you, who are each going to give you 5-minute presentations, giving you a different perspective on cross-border casework, from the challenges that they've encountered as well as best practice that they've seen. I will then take my chair's privilege and ask them a few choice, difficult questions before opening it up to the audience. I think we do need to bear in mind that we are in the pre-election period, also known as PERDA, so a couple of our panelists will be wringing their hands and biting their tongues because they want to say more but can't, so let's bear that in mind. And in that vein, please also be sensible when taking to social media. Before I get started, though, I wanted to get a sense of who's in the room. So just by a quick show of hands, could you raise your hand if you are from the local authority or statutory sector? Okay. What about private sector? So any lawyers? Okay, interesting. I think we have quite a few shy people in the audience as well. What about the charity sector? Okay, yeah, quite a few. Very good. And anyone I haven't mentioned? Okay, so a lot of others as well. Very good. That's interesting. Well, we do have a range of social workers who have a very focused ability to listen, and a couple of lawyers as well who have a very great ability to talk. So we should have a great evening tonight. A little bit about CFAB. So we are the UK branch of International Social Service. We were founded just after World War II, really to help families who had been separated across borders because of the war. We're the only NGO in the UK which specializes in the provision of inter-country social work, and we particularly provide assistance to vulnerable children in public law situations, but also a few private law cases. As I mentioned, we're the UK branch of International Social Service. Our ISS network was established just after World War I and provides assistance in cases involving vulnerable adults and children across international borders. The ISS network is represented in 120 countries around the world, and I think it's important to understand that within the network we have a range of organizations, from charities such as CFAB through to government organizations, ministries of justice, ministries of social welfare, as well as central authorities. Our general secretariat based in Geneva vets all of the ISS members as they come on board. And of course, we have Miglena here tonight, who is representing our ISS partner in Bulgaria. In terms of CFAB, what we do really begins with our free advice line that's open 5 days a week. We get a huge range of calls from people, social workers, police, private individuals who are concerned about some aspect of an international case. We do child protection alerts, so particularly when there is a child at risk of harm who we believe has gone abroad or who a local authority believes has gone abroad. Social service checks to inform child protection investigations, welfare visits, overseas assessments to inform care planning. We do post-placement visits as well, so once a child has been placed abroad, we can follow up to ensure that that child is thriving and to give reports back to local authorities. We do local assistance, so in cases where social workers may be traveling abroad, where although we do not advise that, and we think there's a lot of risks associated with that, we can hook them up with our local partner to help them navigate or do split assessments. We do quite a bit of research and advocacy, and of course we do a lot of training. So both here in the UK, we've recently trained 600 social workers in the last 2 years on international social work and training abroad. Our ISS partners also offer a range of services, which is important to be aware of. CFAB doesn't offer that in the UK, but if it's of interest to you, it's important to know that they do that. Can I get a quick show of hands of anyone who has worked directly with CFAB or accessed any of our services? Maybe about a third, a little less than a third, so that's good to know. Good to make sure you're aware that we're here, and if you need any support, to call our free advice line. So why are we doing the lecture tonight? Why is international child protection, and in particular this lecture, so important to us? We live in a very globalized world. It's, for the last couple of decades we've accepted that businesses are international, but the reality is today families are international as well. There are more children on the move and families separated by borders today than there are since World War II. In fact, there are 50 million children on the move. And if you look at England and Wales, just over a third of babies born in 2017 had at least one parent who wasn't from the UK. And if you look at London, that rises to 2 in 3. Now, that does not include second or third generation born families. So it is a very international country that we live in, and we estimate that there are over 18,000 children in care with family members overseas who could potentially care for them. So it's really important that we discuss some of the challenges and best practice around handling international cases. And of course, if you look at the countries that we work with and the local authorities that call us, in 2018, 2019, the financial year, we took inquiries from 176 UK local authorities on children and family cases involving 127 different countries. Now, the reality is the majority of those local authorities are based in England and Wales. I think it was something like over 90% of local authorities in England and Wales have phoned our advice line in the course of a year. And I'll just give you a little bit of time to look through that list. I've listed the top 59 countries in the hope that you could still read that rather than the full 127 countries. But it's interesting, the sheer range of countries that we get calls about. Of course, within the ISS network, we are the most international branch, so we get more queries about more countries than any other country representative. And we are the experts when it comes to international caseworks and the complexity of that casework. There are a lot of social workers out there that have particular expertise in Poland or in Jamaica, who have had 24 different cases that they've worked on within a local authority. But if you take our principal social worker, for example, Noriko, who couldn't be here tonight because she is actually with the FCO in Barbados doing training there. She's been with CFAB for 3 years, and during those 3 years, she's directly managed 150 different international cases, and she's overseen more than 1,000 international cases. So we really do know about the complexity and the different methods that need to be used with different countries. But don't take my word for it. We've been directly cited as a source of expertise by the current and the preceding presidents of the Family Division, and we are frequently cited by judges in their decisions and in guidance by DFE, FCO, LGA, and others. If there's one thing that I've learned in my time at CFAB, it's that there is not a quick solution when it comes to these international cases. They're complex and they're multidimensional, and it takes a lot of resource to get the best outcome for children. So there's just no two ways about that, and hopefully we can unearth some of the solutions that make things easier in international casework. But I'm going to leave that for our panelists to discuss a little bit more. Let me introduce you to them. Now, they are real experts here, so my font is very small, so I'm going to have to squint. Our first speaker tonight, and I will introduce all of them before handing over to our first speaker, but our first speaker is Richard Morris, MBE. He is currently Assistant Director with CAFCAS, with responsibility for the Southeast region and the National Associate Population. He has over 20 years' experience as a qualified and registered social worker, holding a number of senior management positions inside and outside of his social work profession. Previously, Richard has traveled extensively and worked alongside organizations such as the UNHCR, Prince's Trust Volunteers, and the International Red Cross. He also, most importantly, recently joined CFAB's board. Nuala Moll has founded the AIR Centre in 1993 and is its senior lawyer, specializing in EU law, the ECHR, UNCRC, and other international human rights instruments and their interface. She has litigated more than 120 cases at 2 European courts and the higher UK courts, most of which have concerned children. Miglena Baljiva is a practicing family lawyer for more than 15 years and director of the Inter-Country Casework section of International Social Service Bulgaria for the last 12 years. She is one of the architects of the initiative called Roadshow for Judges and Social Workers, alongside Judge Nick Crichton and Guardian Jill Timmis from the UK, with whom she's travelled in each of the 28 court centres in Bulgaria for more than 10 years to train legal and social work professionals on how to achieve the best interests of the child. And then finally, we have Martin Pratt, who is Executive Director of Supporting People and Deputy Chief Executive at Camden Council. He is also Chair of the Association of London Directors of Children's Services and a member of the ADCS Council of Reference. He has contributed to a number of publications, including chapters in Rethinking Children's Services, published by the National Children's Bureau and Catch-22, and Moving On from Monroe on local safeguarding children's boards. So without further ado, I will hand over to Richard. Thank you.
Thank you. Good evening, everybody. It's always good to be bigged up in intros. Hopefully I will live up to that. And if not, my fellow presenters will pick up the pace afterwards. So I wanted to start with a question as to whether the child's voice is eroded by international borders. It falls well with the 30th anniversary and a subject that we often just discard. I like the show of hands. Has anybody ever heard of home children? No? One? There must be a couple of you in there. The child migration scheme that ran from 1869 to, surprisingly, and I was shocked by this, 1995. The last children to go on the child migration scheme were from Northern Ireland. 150,000 children left our shores on this scheme, and you would hope that over that time that they would learn a few lessons within that. They very quickly learnt that they didn't know what was happening to these children when they left our shores. They were the most deprived, the most vulnerable. They were workhouse children, motherless children, had spent time in orphanages and were out there to support the failing colonies and quite often put to work in quite hard circumstances across Australia and Canada were the main recipients, but other places in the world as well. Now, I was quite shocked to learn that something that was written back at that point. Now, Miss Rye was one of the placement organisations. There were others. Miss McPherson was another. Because of Miss Rye's carelessness, Miss McPherson's limited resources, thousands of British children already in painful circumstances were cast adrift to be overworked or mistreated. Andrew Doyle went out to the colonies to seek these children, to find where they were in 1874 at the request of the London governors, because they were concerned where they were. My worry came when I started looking at our data and the data of the courts and the data of the DFE that comes from local authorities. Well, I had a bit of a head count on some of the cases that have come across our doors. And these numbers didn't reflect the children that were leaving our shores in different guises of different orders. But this is the purest system of collecting data. So, Child Abduction and Custody Act, 49, like so far this year, removal from the jurisdiction, which includes Scotland, by the way, 12, international adoptions into the country, 2, and parental orders, which is under the surrogacy issues, 329 of those. But it didn't actually tell me how many children were leaving the family courts and being placed abroad. And even if I did have a number, I don't have an onward address. I didn't even understand what their final care plan was for checking out their welfare into the future. Then made some assumptions. Because much of the data out there at the moment is a guessing game. There is, as they say, 15 to 20% of our country have family connections outside of the jurisdiction, so with an international element to them. I thought, no, that can't be true. That's almost 1 in 5. Then I looked at my own family. With my generation, we were a Welsh-English family with no other ties outside of the UK. However, and this is my personal bit, my sister married a guy from Malta, so I have 2 half Maltese nieces. My brother's wife married from Colombia, and I have 2 half Colombian nephews. My daughter was born in Germany, works abroad for most of the year. I have a nephew that was born in Gibraltar, and my son works in Germany and is married to a Sicilian. So I think I'm probably making up about 5% of some of their stats. So although the world has become much, much smaller, relationships have become much larger. And it's very difficult to keep track of those relationships and even count those relationships within the family, both domestically and when you go abroad. So some of the other bits of the guessing game was when I looked at nationality over ethnicity. We use self-defined ethnicity in a way that will say British, Polish, British Maltese, but we do not check on people's passports as to what their nationality is, and we don't record that in the same fashion. So we don't actually know whether they came to us with a particular nationality and left our shores. So now, there's an issue of the idea of changing outcomes of care, because when we start measuring outcomes of care, and this is why I have to tread very carefully, because I've seen Judith Masson in the audience, who kindly provided me one of her slides and said, please don't misquote me or mislead people. However, there's a section in there that I was very, very interested in. So, measuring outcomes of care are based on education, they're based on health. They're not based on connectivity, they're not based on relationship, and they're not based on aspirations for children. So, however, there's always that caveat of, does the care population represent society? Now, this is from Judith, direct by email. Thank you very much, Judith, on this one. And I ignored the first, or the outside columns, and I was drawn to that centre of those missing children. And I inquired as to that. I'm like, now this is a very, very small study. I'm talking numbers of children here, but there is still a missing population that are in kinship care that we no longer can track. Now, they either left the jurisdiction or they're not recorded anymore by the local authorities because they don't get funded. They may have left care, I'm presuming as well, Judith. However, I went for the last week and scaled up on those children that were SGOs that had an ethnicity of another nationality. And I found that there were great more numbers out there that we did not have a forward story for. So I looked at 100 case files under that guise, and 75 of them did not have a forward story. And the presumption is they've left the British shores. So my points to all this, because I'm conscious that I only have 5 minutes, I'm sure, Carolyn.
It's fascinating.
My point to this was I wanted to have a really nice story to say that we've learnt through history. And over the last 150 years, we've gone beyond what was cataloguing children, because that's what they did with home children. At least they knew where they were going. And we've reached a point where they leave the shores, and it would suggest that we don't care. We don't have any forward stories. The data shows me that we don't have a real picture of how children that are sent abroad to live with connected people, whether they fare well or whether they don't. We don't know what their home circumstances are, and we don't know their through childhood to adult story. So I'm going to leave it with that conclusion that the child's voice in this circumstance has not been eroded, but it's lost. Thank you.
Thank you very much. I don't have any slides. I'm incompetent enough at using my computer when I'm focusing entirely on using it, but using a computer and speaking at the same time is completely beyond my capabilities. I was thinking, as I was listening to what Richard was saying just now, about the range of cases that we have been involved in Strasbourg, in Luxembourg, and in the higher courts of the UK. And they've been for a whole range of situations. So they've been migrant children, asylum-seeking children, refugees, children who've been abducted, relocated, or deported, children of unrecognised parentage, children wrongly taken into care or wrongly not taken into care, children who have been parties to international adoptions, and the status of children who are in kafala relationships, which is the closest that Islam comes to recognising something akin to adoption. So it's a broad range of cases that we take, but one of the threads that goes all the way through it, the litigation that we do on behalf of it, is that we are constantly reminding the two European courts. It's a slightly more difficult problem in the UK, but we're constantly reminding the two European courts of this mantra from Article 3 of the Convention on the Rights of the Child. And I think it's very important that we just read it carefully, because people say, oh yes, Article 3, best interests. If you read it slowly and carefully, it's in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies. The best interests of the child shall be a primary consideration. The primacy of the best interests of the child is writ large in Article 3. And because I don't have any other slides, you're going to have the opportunity to read it again and again and again as I go on talking. I'm going to talk about, I think 5, but it might be 6. My maths was never very good. Groups of children. And the first one is child migrants, and in particular, the child migrants crossing the Mediterranean Sea and how they are dealt with. And I did think of putting up some of the harrowing pictures that the internet shows us, and indeed some of the harrowing pictures that I have on my own phone from first-hand experience about those children. 678 children have recently died crossing the Mediterranean. And many more have disappeared since they arrived in Europe. Interpol estimated 10,000 disappeared children in 2016. And those unaccompanied or accompanied minors who survive and don't disappear are often not much better off. Clearly, life is better than death. In the camps on Lesbos, the other Greek islands, and now increasingly in Bosnia and Herzegovina. And we have acted with the lawyers, taking the cases to the European Court of Human Rights that have highlighted the unacceptable conditions in which these children are kept in the camps, which are supposed to be providing reception conditions for them. In a wonderful case that was brought not to a court, but to the European Committee on Social Rights by our colleagues at the International Commission of Jurists and ECRE, the committee ordered the Greeks to take immediate measures to alleviate the problems of the children, food and accommodation and lack of medicine and medical care, lack of education, and those are now being put in place. We were working all day yesterday on a case where a child was rescued in the Mediterranean. He was 4 years old, traveling with his aunt. And the Spanish authorities rescued him, took him to safety on the shore, took his aunt and sent her off to the mainland, and put this 4-year-old child on his own in a protection centre in Melilla. It was almost a year before he saw any of his blood relatives, and it took his mother several months to be able to persuade the Spanish authorities that she could even visit him. This is not the way to treat children. And I've started with this topic because it's probably the one that's worst. So now we can move on to something which is a little less harrowing, but is a very new problem, which is the rights of children who are born as a consequence of surrogacy arrangements entered into abroad. These issues are usually approached from the perspective of parental rights. The parents are not recognised as parents of this child. They're not allowed to put their name on the civil register in the countries of origin. But all the cases we have intervened in from the Air Centre, we have always been looking at this. In all actions concerning children, has the state put the best interests of the child first? And we intervened in the first case that went to the European Court on the interpretation of a provision of French law. We have just put in an intervention representing the interests of the child in an unpronounceable case called Dotter against Iceland. Anybody Icelandic here who can correct me? No. And then, of course, there's the case of A in Norway, which is also coming up on the horizon. It's a very, very complex issue, and it's almost always approached as a parental rights issue, and we think it has to be looked at as a children's rights issue. Then also today, it's been a busy day today. Also today, spent quite a bit of the morning with a Dutch colleague, trying to see if we could get interim measures from the European Court of Human Rights in order to get the Dutch orphans who are in the Syrian camps brought back to the Netherlands. As everyone knows, some of the children have been brought back to the UK, but we understand that now a block has been put on that because of a different perception of what is in the country's interest by the Foreign Office and the Home Office. And we hope that somebody is looking at what's in these British citizen children's interest as well. The UK is not a party to Protocol 4 to the European Convention on Human Rights, so we don't have an obligation under the European Convention on Human Rights to admit our own nationals, but the Netherlands is, and we're going to pursue that issue in Strasbourg. Then there's the rights of children to be heard, Article 12 of the Convention on the Rights of the Child. A wonderful decision against Georgia, NTS in Georgia, has highlighted for the first time the fact that the European Convention on Human Rights also requires that the provisions of the Convention on the Rights of the Child are respected, and in particular that the child is heard. A case called A and B against Croatia was decided earlier this year, where the child was too young to be heard physically, but there was no representation of the child in the litigation, and it was so clear that there was a conflict between the warring parents in this case that the court in Strasbourg, for the first time ever, asked the Croatian Bar Association to recruit an independent representative and appoint an independent representative so that the child's interests could be heard in the Strasbourg litigation. And the court in Strasbourg is now going through a process of overhauling its rules of procedure in order to ensure that children are better represented and better heard in Strasbourg.
Yeah,
That's very interesting.
You've got, I know you're a lawyer, but you've got 1 minute.
1 minute? A whole minute? 60 whole
You can
seconds?
fit a lot in, I'm
Oh,
sure.
you can say a lot in a minute. So one of the things that's coming up now, of course, is it begins with B. We don't want to say it really. But there are going to be lots of complications if and when we ever leave the UK. I don't think the charity commissioners will get cross with me if I mention it. The Hague Convention cases, the abduction cases, are of course going to become unbelievably complicated. But perhaps the thing that most people haven't thought about is not just about how the Brussels II bis, the 1980 Hague Convention and the 1996 Hague Convention will work, but how the UK will now be excluded from the coterie of the 27 other member states who all meet together in The Hague when discussions are taken about how to take forward the proceedings of the proceedings and procedures of the Hague Conference. And that's going to be a huge loss. We all thought it was dreadful when it came in, that the 28 member states all had to sit in a room together in silence. Finally, when we lose, if Brexit happens, we will lose Article 24 of the Charter of Fundamental Rights, which means we will no longer have the Convention on the Rights of the Child in our law as such at all, and Her Majesty's government, of whatever complexion, frequently argues that the Convention forms no part of UK domestic law. So we're particularly happy that Scotland has done the right thing and has now brought the Convention on the Rights of the Child into Scottish law, so that, or is in the process of doing it. And so that in Scotland, children will now be able to invoke the Convention on the Rights of the Child directly in Scottish courts. And this is my final point now, it's about the courts. As everyone in this room knows, judges are not allowed to hear either private law cases or public law cases until they've got the relevant ticket. You have to have been trained to do children cases. But children who have come through the sort of trauma that I was describing earlier, their rights are adjudicated by judges in the immigration tribunals who have no training at all. And we have been campaigning for a long time to try and make sure that immigration judges had training in understanding children and the minutiae of the Convention on the Rights of the Child and child law. And if we can't have separate courts for these children, can we at least have judges who know what they're talking about? Thank you.
Thank you very much. I'm very happy and feel privileged to be here. And I would like to thank Caroline and her team for the invitation to join you for this very interesting event. Thank you, Caroline. So, as you heard, I come from Bulgaria. Bulgaria is a country in Southeast Europe. And we are surrounded by Romania to the north, by Serbia and North Macedonia to the west, by Greece and Turkey to the south, and by the Black Sea to the east. The population of Bulgaria is about 7 million people, of which 1,320,000 are children. In the year of 2000, the Bulgarian parliament adopted a very new piece of legislation called the Child Protection Act, which fundamentally changed the philosophy and the attitude towards children whose parents were not able or were not willing to take care of them. And I have to tell you that this Child Protection Act was drafted with the help and with the assistance of English lawyers, and that is why it was based on your Children's Act in 1989. So the Bulgarian Child Protection Act set up a brand new child protection system in Bulgaria because until then, all children with any kind of problems were placed in big isolated institutions very far away from the biological families. At present, the child protection system in Bulgaria includes 147 child protection departments all over the country, and these child protection departments are similar to your local authorities. Besides, we also have private service providers for children and families at risk, and these are both consultative and residential services such as community support centers, mother and baby units, daycare centers for children with disabilities, foster care, and etc. Now I can give you some statistics for the last year. As you can see, we have about 5,000 children in kinship care in Bulgaria, about 2,300 children in foster care, and about 1,000 children in this very big institution that still exists, but we are in a process of deinstitutionalization, which takes a lot of time. We also had about 15,000 children receiving consultative and social services, as well as residential care services in small family-type homes. Unfortunately, this year we have about 45,000 children not in school, and most of these children are Roma children, because education, unfortunately, is not available for the Roma families. Oops. For the last year, we had about 800 children adopted both in Bulgaria and overseas. And we had this very interesting phenomena called Skype children, and there are about 300,000 Skype children in Bulgaria. And these are children whose parents live and work abroad to ensure better life for their families. So these children are left with their relatives, members of extended family, and some of them are in institution as well. And for 2017, we had about 1,300 refugee children, of which 656 stayed longer in Bulgaria and used social, medical, and educational services in our country. As you heard from the previous presentation, it is always hard to determine what is in the best interest of the child. And I'm very happy that in 2009, our Child Protection Act was amended and we introduced the welfare checklist of Your Children's Act in our legislation, of course with slight differences. This innovation was possible due to the road shows that you heard about for judges and social workers who work with children. And all participants in these road shows, which were judges, social workers, staff of institutions, probation officers, medical doctors, and etc. So they were all very impressed by your welfare checklist, which was presented by Nick Crichton and Jill Timmis. And when I was invited in 2009 to participate in a working group in charge to amend our Child Protection Act, I proposed to the legislators on behalf of all these participants in the road shows to introduce this checklist in our legislation. And this is how it works. Now we have in our Child Protection Act your welfare checklist, and this is the evidence. And last but not least, sorry, I want to say a few words about kinship assessments within our ISS network. Every year, ISS Bulgaria receives kinship assessments from all over the world, and vice versa. We send kinship assessments produced by the Bulgarian social workers to our colleagues from the network. In terms of the structure, I would say the assessments are more or less the same, as they usually have the typical three parts: facts, analysis of the facts, and conclusions or recommendations of the social workers. However, my observation is that when it comes to the content, sometimes the Bulgarian social workers are more focused on the physical or the material conditions of the family that is being assessed, rather than the emotional relations and the attachment between the child and the family members. Of course, this is due to various reasons, such as lack of proper education, very little or no training at all, lots of cases, low salaries, and etc. However, we often receive positive feedback from our colleagues from the network about the quality of the reports we send from the Bulgarian social workers. And I even remember a case with the UK when a local authority here was very happy about the report that we sent, produced by the Bulgarian social workers. So, thank you very much for your attention, and if you have questions, I would be very happy to answer. Thank you.
Right, follow that. When I was thinking about how to be the fourth person on such an august panel, and the brief was that we were to offer you a provocation for the questions and a discussion about the dilemmas. The thing we alighted on in preparing was that perhaps I'd bring a case study from Camden, or a couple of case studies that would kind of illuminate, reconnect all of the kind of the legal and technical arguments with an individual case. And I've looked at some cases, and it occurred to me that they're so specific that it would be possible to identify potentially the individuals concerned, and that felt a bit intrusive and probably unwise. That then left me with a dilemma. So I've got to have something to say to you, hadn't I? So I did want to bring, though, I suppose, a practice perspective from a local authority, and particularly from social work, which would have the same kind of impact. But the way to do that is it's either for me to imagine what I ought to say, or to actually ask practitioners to talk to me about the cases, and for us to extract some of their comments and thoughts, what you might call the practice wisdom and the dilemmas. So that's what we've done, and we'll see how this goes. The first thing they wanted to really connect with was, what must we do for children? This is about values as well as about legislation. It's about how we, not just the things that we have to do, but the things we must do. So that implies that. And the first thing, obviously, the first thing we should say is that we must ensure that we're complying with Article 3, otherwise I'm going to get into terrible trouble. But essentially, ensuring that we're prioritising maintaining family life for a child. Now, we've already said families are international in many cases. If that's not possible in the immediate family, then we need to explore extended family. Now, this might sound obvious, but there is there's been, I think, I'm being very careful what I'm saying because of the pre-election period. This is not a political point, but I do think there's been a move in recent years towards a kind of procedural approach to social work, which has drawn people into the care system to the exclusion of that prioritising the maintaining of family life. And therefore, we've had to think very carefully about that, particularly where families are international. In Camden, we've got a super diverse community. We've got a super community of all sorts, but it's super diverse. It's central London. We're part of a world city. There are 160 languages and dialects spoken in our schools. It is the experience of our children. Over 60% of the children in Camden have English as an additional language. So it is a very, very diverse picture. But they're our children, and we have to think about how we are prioritising maintaining a family life, particularly where, if that's not possible with the immediate family. So we have to do the best thing for the child, with the child, and we have to hear both the voice of the child actually and the experiences of the wider family network. And so in order to do that, we need to explore all the options. And this was one of those bits of wisdom that I hadn't kind of expected until, of course, talking to frontline social workers and managers. So we have to ensure that there is information about this child's family, even if the decision isn't about residence, because this is the child's family. And having that knowledge and that contact means that even if a child isn't going to live outside the jurisdiction or is going to be in care, they have a lifelong family network, and that ought to be maintained because we're prioritising maintaining a family life. We talk about supporting families wherever possible, intervening decisively to protect children where necessary, but that doesn't mean to the exclusion of that family life. And so we have to work across national borders. So then what can we do? Well, first of all, it's incumbent on local authorities and indeed nationally for us to plan for the population profile that we work with. So if your default position as a local authority is, oh goodness, we've got an international family here, what are we going to do? You haven't really thought about the job, have you? If you're still, your default position is to behave as if your population is the same as it was 20 years ago or 30 years ago, and we've heard Richard's family story, and we could all tell those family stories, every one of us could tell those family stories. So you have to think about the profile that you're going to work with. You have to have a position where you're going to be creative and flexible in the investigation of family networks, and I would say careful and respectful as well. The state is quite often a very blunt instrument, and we love to get procedural, and it's very possible in these cases to tick all the boxes and miss the point. You also have to invest in the continuous professional development of your workforce. You have to think about how you're equipping people to do this job, not just in terms of, and that includes your legal services as well as your social workers, as well as your family workers and your teachers. So you have to invest in that. That has to be part of the responsibility of working with a diverse community. So in Camden, we've developed the skills and knowledge of social workers to work directly with welfare services in a number of countries where we have regular, so it's one of those cases where we do that. But you also have to know where the limits of that is. So assessments need to be completed and legal advice sought both in the UK and in the country where the extended family lives. You have to identify trusted sources of advice and professional partners. This is where there's a little mention for our host this evening, because CFAB are one of those trusted sources and professional partners, and you've heard at the beginning about precisely the range of things that they offer. So a little word from our sponsors, but had I been giving this talk anywhere else, I would have still said that. So I think that's just to... prospective carers need to be financially supported, and that's true in kinship care in the UK, and it's true in kinship care internationally, and actually we've got to just get to grips with that. I mean, it's very important, and there are additional costs which have to be thought about as well. If you compare the costs of ensuring a child and their new family carers are able to travel to London to see siblings, to keep the family connected, and then you compare that to the costs of what we might call stranger care, or having somebody in the care of the state, then they pale into insignificance. If you think about the benefits, they're enormous. It requires a different approach. So just to underline a few of the challenges, and then we'll get to the really tricky bit where you get to ask us questions and we struggle to answer them, and Richard and I go, oh, sorry, it's the pre-election period. Understanding that sometimes subtle differences in legal and welfare systems, whilst also being clear about the fundamentals of the rights of the child. But actually, it's quite interesting when we're talking about adoption internationally, particularly where if we reverse it and we have children in the UK and we're thinking about our approach to adoption. Actually, the UK's approach to adoption, am I allowed to say this? I think so, is internationally very unusual. And sometimes I think practitioners and even courts are quite shocked. They get into the routine of thinking that this is our approach, but it is the most draconian thing the state can do to remove your child from you and give them to somebody else. And that sometimes that is that really does cause a great deal of tension in some of those discussions. Accessing good specialist advice in some cases and in some jurisdictions is still difficult. See my previous answer. Check any order made in the new country doesn't reduce the choices for a child later in life. A good example, there are many countries where dual citizenship is not permitted. So if the child is now going to cease to enjoy the rights and freedoms of a British citizen, stroke subject, depending on, and is going to take on the citizenship of the country to which they are going, then you have to consider whether or not that's going to have what the long-term impact. I think you have to do it with your thinking about the welfare principle, the primacy of that. Consider the country's political situation, human rights record, Obviously, that has to be included in deciding final plans. It doesn't preclude any particular outcome, but you have to do that knowingly and carefully. Consider the health provision, access to education, and important parts of future planning as well, including potentially funding. And local assessments must be of high quality and timely, whether provided by the state or local agencies, though obviously there's some excellent practice in Bulgaria, so I just wanted to mention that. So that was that. Hopefully that just grounds this back in some of the practicalities, and I'm very happy to take any questions.
Great. Thank you very much to all of our panelists tonight for sharing your knowledge and expertise. I'm conscious that everyone has run over in their presentations, so rather than taking chair's privilege and asking some of the very difficult questions that I have prepared, I will do a bit of both. I'll give you one and I'll take one, because I know that when speaking with some of you over coffee earlier, you actually have a lot of the same questions that I have. You know, I just want to say, again, thank you to our panelists, to Richard, really, for highlighting some of the risks around the children that are out there who don't have a voice. And I will flag that we are running a campaign called #OutOfSightOnOurMinds, which is very much highlighting the fact that there is no tracking of these children who are going overseas. Nobody knows really what the numbers are. There's no clear and comprehensive national guidance for local authorities for the full range of countries. I mean, Martin's mentioned 160 languages in Camden alone. Okay, how is it possible for a local authority social worker to navigate 160 different countries without any guidance at a national level? So I urge you to please check that out. Out of Sight on Our Minds. Nuala, of course, has given us a good overview of the law and some of the risks of Brexit. Maggie, I think, very helpfully has given us a picture of the Bulgarian situation, and probably a situation that's more akin to what we have in the UK in terms of countries than other countries. And again, I emphasize 160 languages in Camden. A lot of those countries are not going to have similar legislation to the UK. The child welfare system is not going to be modeled after a UK system. And how difficult is that to navigate? And then, of course, Martin gave us an excellent practice perspective, so thank you for that. Do we have any questions? I've given you some time to think of your burning questions. Do we have any questions to start off, or shall I? We do have one right there. Ruma's bringing the microphone over. Thank you. Do you want to just say who you are and then ask a question?
I'm Rachel Bailey. I'm an independent family placement worker. I suppose one of the questions is, it's more a legal question, and I'm sorry if it sounds a bit naive, but adoption is adoption and it's recognised internationally. SGOs aren't recognised internationally, and from my experience, a lot of the children we're placing with families now abroad are looking on SGOs, and it's very difficult to find a comparative legal order. So how are we dealing with those children, and how many are actually going out the country on SGOs to countries where there's no recognisable order that parallels that?
Thank you, Rachel. That was actually the first question that I myself had prepared, particularly with the review happening of special guardianship orders and the fact that we can't test those placements in advance. I do personally have some thoughts, but I think I will open it up to our panel first to see if they have anything they want to say.
Well, only to say that SGOs are very, very similar to two phenomena that we've dealt with in European litigation recently. One is to the Algerian kafala that we had in the case of SM Algeria, which went from the Supreme Court here to Luxembourg and back again, in which we had testimony from the Max Planck Institute in Hamburg, which showed that an Algerian kafala was almost identical to an SGO in the UK. But of course, an SGO is very like what is known in most European countries as an adoption simple. So they have two forms of adoption. They have adoption simple, which gives a new permanent home to the child, and they have adoption plénière, which gives a new permanent home to the child, but severs all the links with the birth parents. And SGOs are so like adoption simple. And when we took PCNS against the UK to Strasbourg, what we were really arguing for, only the court wouldn't take the bait, was that they would suggest that having only one form of adoption in the UK, and we didn't have SGOs in those days, was a blunt instrument that wasn't going to be able to be tailored as a proportionate response to a child. So I think those are some of the criteria that could be it.
Maybe just a line. In Bulgaria, we don't have SGOs, but I can tell you about a particular case we had with Germany, for example, in our network. So the case is like this. The family is Bulgarian, but the father killed the mother in front of the child. So the father now is in the prison, the mother is gone, and the sister of the mother decided to take care of the child, but the sister is living in Germany. So probably upon advice of a lawyer, she applied in Bulgaria for an order. We have two types of adoptions in Bulgaria, full adoption and partial or non-full adoption. So she applied for non-full adoption, and the judge in Bulgaria requested a report about her situation in Germany to decide whether or not it will be in the best interest of the child. So we approached our colleagues in Germany, and they received report from the Youth Welfare Office at the residence of the aunt in Germany, and we provided the Bulgarian judge with this assessment or social report, and the judge made the decision that the child shall be non-fully adopted by the aunt. And what we did actually is that we had the decision of the Bulgarian court, and we informed the Youth Welfare Office in Germany about this decision through our colleagues in ISS Germany.
There's possibly a very practical answer to this, and in simplistic terms, you still have to apply the welfare checklist to domestic cases, whether they're staying here or going abroad. Nowhere in the checklist does it say we'll find the right order for the destination country. So if we are saying that our level of adoption is to sever ties and remove PR, what you do is prevent that child in the future of having a relationship most often with their family in this country. That might not be right for the child. The welfare test would not be made out in those circumstances. There is a call and there is a very good argument for testing out placements when we are placing abroad, whether that be under adoption or whether it be under SGO and trying to find a mirror order. And that is being considered as part of the Public Law Working Group, and people have seen the consultation on that aspect. So there are means, as it were, of looking at that subject, but I don't think it's easy in any fact. Even when we look at sister countries as the US, where we're asked to orphan children for them to relinquish their citizenship here and take over in the US. I'm not sure I want to orphan children on a regular basis.
Yeah, thank you. And you know, I think Rachel, you're probably making the wider point, that is that, you know, really sustainable, and you know, are there merits to considering adoption in some cases? I will just say, and I will put IAC on the spot, because we have asked them to write an article in our next newsletter about when is adoption a better you know, avenue for a child than kinship placement. So hopefully you'll all signed up to our newsletter, and you'll get a more complete answer to that in January, written by the IAC. But you know, I just would really, you know, reiterate, I think it is a problem. It's something that we're concerned about. At the end of the day, any social worker who's working with a child has to be satisfied this is the best placement for a child, and that that's the right order of the orders that we have, in front of us. And, if that's more complicated when you're working abroad, and if that means extending the time scales for a court, if that means getting more information, additional assessments, looking at different ways of getting information, split assessments, local assistance I've mentioned, flying that carer over to the UK to interview them, I think we need to be thinking creatively and getting as much information as possible to be really satisfied that that is the best placement of for the child, actually regardless of the order. Because if you're going to place a child with a family member abroad, you can't be thinking, ooh, but we might want to take them back, or we might want, to do something different, whether it's wardship. Wardship has also been considered. So hopefully that scratches at some of the issues. Any other questions? Burning questions? Perhaps I will ask one of my difficult ones. So, Martin, you actually said, I was surprised and pleased to hear you say that local authorities do have an obligation to pay allowances abroad to kinship carers, and assuming that they are eligible for that and means tested, etc. I wonder if any of the panelists, or in fact anybody from the audience, wants to talk to some of the risks and disadvantages associated with paying kinship carers abroad. Or not.
Would you like me to kick it off? Rates of payment in comparison to GDP or local currency is a massive issue that you wouldn't want to underfund or overfund a family, and money should not be an incentive for taking on your own kin. However, that does come into play, and it's got to be one of those sensitive things that needs to be approached. You can't apply carte blanche across the board just based on the national GDP. So it has to be fairly localised. Many families would find that extremely intrusive, particularly when they're just putting their hands up for one of their family members. So I am a big believer that if you support a placement, you support it well, it will be successful in the most part. I don't know whether you've got a different view on that.
No,
No?
not surprising.
Good.
I mean, the point that I was making, I think, is that it is said, sometimes it's said by some of my colleagues, that they actually kinship care is kinship care irrespective. And the point that my team was making, the point that I'm making, is that if we are serious about the welfare principle, then we shouldn't allow that the funding of placements or the funding of this activity to be an impediment to securing a permanent placement in the extended family or in the kinship network. And I think that it comes back to that point about being flexible and creative, and most of all, putting the interests of the child at the heart of the decision.
Thank you. And again, oh good, we've got a couple of questions. Good, I'm glad to see that. Do we have the mic coming around? Okay, just while room is going in, I will just add, I think, it also goes back to the point that these are not domestic placements. There is not a simple and quick solution. They're going to be complex. It's going to be multidimensional. You're going to have to try different things with different cases in different countries with different children. Every situation is unique. That's the reality. Sorry, go ahead.
I was going to sort of follow on from what was being said about the placement support. I'm Barbara Babbitt from the Intercountry Adoption Centre, working on the Outbound project. So we're working on permanent placements abroad, and some of our work overlaps with CFABs, and we work together on some things. What we're encouraging social workers and lawyers to do are really front load their questions about post-placement support, because from the inquiries we're having, there is a massive variation across the country. Local authorities, I mean, it's very nice to hear what Camden are doing, and we're not surprised by that, because Camden have got an ethos where they would take that attitude. But there are some local authorities that really are feeling quite sort of relieved, if you like, that their financial involvement won't continue once the child is placed. So what we're encouraging social workers to do, even at the viability stage, not to promise money, but to really ask the right sorts of questions that give you a picture of what you need for that child. I mean, an obvious example would be a child with particular health problems. What is there in that country to meet those needs, and what costs will it be to the kinship carer? Because the last thing you want is that placement to break down abroad.
Yeah.
It wasn't really a question. It was
No, but
adding on to what
that's
you
a
were
very
saying,
helpful
really.
addition.
Yes.
Thank you, Barbara. Yes. I think we had one other question. Sorry, there we go.
Hello, I'm Florence Koenrink of Y Family-Based Solutions. I'm a consultant on moving from institutional to family-based care around the globe, essentially. I agree that, I mean, obviously there are a lot of pitfalls in offering money, but there's also the often heard complaint, if we would support families, including extended families, to the extent that we support group homes or foster families, a lot more kids could actually stay within their own families, because a lot of time that is what is lacking. And obviously that's a much harder sell when it goes abroad, the money, rather than staying in the country. But I do think that that's a really important point. And the other thing is, you were talking, we want to avoid placement breakdowns, and we want to avoid children ending up in substandard care as a result of that. And I think the point that is made too little in these situations, yes, it costs money, it's quite expensive to fund all these things, give the support that is needed, but it is an investment, because if you have repeated placement breakdowns, there is going to be not just the next placement, it's a cost to society with the impact on mental health, the higher chance of criminality, and a whole range of issues which comes at a huge cost to society that is much, much lower if you actually invest at an early stage.
Yes, thank you for that, Florence. That's, I think, really well said. And I will also take this opportunity, if anyone hasn't seen the campaign that Family Rights Group is running around domestic kinship care and increasing support for domestic kinship carers, because I think there is a lot of placement breakdown simply because the families aren't well supported. So thank you for that. Other burning questions? Okay, I will take one of my own, which is around, I think probably a little bit of an ethical dilemma some social workers face, which is around how should or can a social worker continue to monitor a case once it leaves that national jurisdiction. Because I know a lot of social workers are concerned about placing children through special guardianship orders and wanting to ensure that that child is safe and thriving in the same way that they might be able to do through domestic SGO, because that child is domestic, and therefore if something happens, we know that the system here is going to pick it up. But how does that work with the balance against the right to family life and right to private family life? And if we really believe that this is the right placement for a child, shouldn't that child just be with their family and get on with it? So I might look over to Maggie around that, just because very often we are placing children in countries abroad, and how that might be perceived in terms of a UK social worker wanting to follow up on a case in another country where jurisdiction has ended.
I think this is a very difficult question to answer, but if we review our experiences and practices in the network of the International Social Service, I can remember of a few cases, maybe 8-10 years ago, with countries from the European Union, and we were very successful in reviewing and collecting information after the placement was taken place. But my observation now is that with the general data protection regulation, it will be more and more difficult to follow this practice, because once the child leaves the jurisdiction, it goes to another jurisdiction, and if this second jurisdiction does not have rules or practices in terms of monitoring and providing information to the first jurisdiction, due to this data protection regulation, it will be very difficult to ask social workers or child protection system to answer this question. But we had experiences like this sometimes ago, some years ago.
Okay,
Yeah.
good. Just for my part, I would just add that there is always the option of getting parental consent to follow up in 3 months' time to make sure everything's going well. And of course, it does highlight, I think, the need for local authorities to notify foreign authorities that a vulnerable child's been placed in their jurisdiction just in case anything goes wrong. David, yes. I'm going to probably take David's as the last question, unless there are any other burning questions, so prepare yourselves.
It's a bit intimidating to be the last one. David Jones, I'm a trustee of CFAB and involved with the International Federation of Social Workers and other things. And I was just wondering if the panel might want to reflect on how UK social workers doing this work are seen abroad and whether we think enough about that in this context. You talked about the Bulgarian law being based around the British law. There's sometimes a tendency for UK social workers to think, well, yeah, we may feel embattled and criticised, but we've actually got some quite good tools and we know what we're doing, and it's good for children that it's quick, and these countries that take so long, we should be frustrated with them, and, well, we know that it's right that children should be placed for adoption quickly, and other countries find that, frankly, racist. I use that word advisedly because some embassies in the UK have actually used that language to describe our practice. So I wonder whether we are as sensitive as we should be. We're a hugely international country, but we are connected in these ways. And do we think enough about how we are seen when we go into other countries to do assessments, especially when people send social workers to other countries? And should we perhaps be ready to work with a little more respect for the experience and knowledge of our colleagues and find ways of working in partnership in a more creative way? You wanted something a bit controversial, so...
Thank you, David, yes.
Have I been controversial enough?
Yes, no, I think...
I'm sorry, it's pre-election period, so I delete the word racist.
I think it's very interesting that there was a big Grand Chamber case in the European Court of Human Rights last year called Strand Lobban, which was meant to be the definitive ECHR ruling on non-consensual adoptions. And it was about whether or not the birth mother had the right to protest when the state wanted to place her child for adoption, but there hadn't been any parallel planning from the time the child was born. And what was very interesting, the reason why I'm referring to it now, is because what was very interesting was when it was in the lower chamber, before it went to the Grand Chamber, it was pointed out that the UK and Norway were the only countries in Europe who had such a gung-ho attitude to adoption and would place children for adoption long before they would be placed for adoption in other jurisdictions, because in other jurisdictions they would be placed in some form of long-term foster care, special guardianships, even adoption simple, the simple adoption, but not with the full adoption. And that was peculiar actually to Norway and to the UK. And the Norwegians got a bit of a shock when they got the judgment in Strand Lobban. We intervened in that case because we thought it was very important to put the facts before the court, and we had Claire Fenton Glynn from Cambridge who worked with us on the intervention. But I think it's quite interesting to go to the other side of the mirror and see how other people see you, and I think it was an important question to ask.
What was the conclusion of the case?
That it had been overzealous. Yeah. I'm very happy to send you it and a comment that we did on it. It's called Strand Lobban.
Any final burning questions? I will then ask my panelists if there are any final burning points that they wanted to make or didn't get a chance to make yet. Nope. Good. I would like to thank our panelists, of course, for spending their time with us and sharing their expertise. Can we give them a quick round of applause? And I will just very quickly say one final word about why this is so important. I hope you've found that I really tried to tease out some of the challenging issues and make it as controversial as possible. And that is because this is a very complex area of work. However, if there is one point that I do hope that you take away tonight, it's that international kinship care is a viable option. Family abroad is a possibility for children. It is a complex area, absolutely. That doesn't mean that children should be deprived of their right to family abroad. And I think this is a really important point to underscore because we have focused on those challenging issues. We are in the process of doing a freedom of information request to local authorities to ask about how many children they have explored family links abroad for, or how many children they've placed abroad. We're still in that process. However, I'm a bit taken aback by how many local authorities are coming back and saying, we don't have any children who have families abroad and we've never placed a child abroad. And in this world, in this country, that simply cannot be the case. So despite focusing on the challenging issues, I do want to be very clear that placing children abroad with families is a viable option for a lot of children out there. If there are other issues that you'd like to discuss, I think we might have wine over here. I did see wine glasses when we were here in the beginning, and I thought, where's that wine? But we do have a glass of wine for you if you'd like to have a more informal conversation. Thank you again. Thank you to Herbert Smith Freehills. Have a good evening.